Good evening. I'd like to call to order the Town of Dudley Planning Board meeting for October 28th, 2015. Members present: Mark Mazziotti, Sean Guerin, Marsha Wagner, clerk of the board, Tom Holt, vice chairman, and myself, Guy Horn, chairman. Our first item on the agenda for this evening is approval of minutes. First set of minutes would be from September 9th, 2015 meeting. I got to read these over today. They looked pretty good to me. Has anybody else had a chance to look at them?
I did.
Can somebody make a motion for the September 9th meeting minutes?
Mr. Chairman, make a motion to approve the meeting of September 9th, 2015.
Okay, we have a motion to approve. Do we have a second?
Second.
We have a second. Motion and a second. All in favor?
Aye.
Unanimous? I believe everybody was here for that meeting. The next.
No, there were two missing from that
Was there?
meeting, myself and Mr. Holt.
Okay. Yep, you're right. Okay, so just have watched the meeting and want to sign them, you can. If not, then the other three of us will sign those.
While we're signing, Mr. Chairman, I've read and digested the minutes of the 9/23 meeting, and I'd like to make a motion to approve them as read.
Okay, we have a motion to approve 9/23.
Second?
We have a second. All in favor?
Aye. In the 10/14 meeting, myself and Mr. Guerin were not present, so.
I read the October 14th and make a motion to approve them as written.
Okay, we have a motion for October 14th meeting.
Second.
Second, all in favor?
Aye.
Aye.
So we can approve that. That one's missing. 23rd. I was not in. She's missing. Missing the last sheet of 20. Copy of that. All right, that's the 23rd. Minutes. We'll have to probably sign up next meeting. Okay. All right, moving on to our next item on the agenda, item B, A&R lots, Rick Para, referring to Center Road and a plan for the Fauchets. If you could explain, that would be great.
Yes, this is at 149 and 151 Center Road. One lot is owned by Lee Fauchet, and the other one is owned by Lee and Lois Fauchet. What they're doing is swapping or conveying a small piece of land, parcel A in the back, from 149 to 151. There's a garage in the back that with doors on this side, and right now they have to travel over the opposing property to get into the garage. Right now, it's not an issue because they sort of own both sides, but if they convey one, they want to to own it so that they can access the garage cleanly from, from their own land. And there is an existing right-of-way that goes through to the other garage. In this lot line shift, in order to access the garage, that needed a variance to go for 2 feet from the small garage on 149.
Yep.
The zoning board of appeals voted to approve the 2 variances earlier this month, and it's in pending the appeals. It's in the appeals process. So as of right now, the zoning board has not issued the variant, but they voted to approve it.
Okay.
It's also, the large garage on 151 was also in setback violation, even though the buildings existed before zoning, so they weren't in violation. So this is kicking over a little bit to make that so that that conforms also.
And you're asking for one waiver?
The waiver for the contours.
Topography, yep, okay.
No new lots being created. It's,
And they're both going to use the existing driveway?
yeah, there's an existing there's a right of way over that driveway.
Okay. What would happen if we approved this plan and somebody appealed their variance?
I would consider that highly unlikely.
Okay.
There was nobody at the ZBA meeting to appeal to, to comment on it, so,
Yeah, it's
so
too,
there didn't seem to be any issues with it.
okay. All right. Anybody else have any other questions?
Mr. Chairman, all the fees have been paid?
Yep, we have a check here for $200.
Want to give me that form,
Yep.
please? Thank you. Mr. Chairman, I'd like to make a motion to allow the waiver for the
Topography, yeah.
contour,
Yep.
yeah, topography for the A&R plan of Lee Fauché, pre-existing lots, non-building lots, parcel transfer, 349 Ashland Ave, Southbridge, Mass. 1550, or 1550. Book 16302, 48510, page 30, 394. Tax plate 222, parcel 23 and 24. And I so move.
Okay, so we have a motion for the waiver. Do we have a second?
Second that.
We have a motion for the waiver and a second. All in favor?
Aye.
Aye. Unanimous? Okay, now we'd be looking for a motion to approve the A&R plan.
So, Mr. Chairman, I will make a motion to approve the A&R plan for the location 149 and 151 Center Road, Lee and Louis Fauché, P.O. Box 1498, Dudley, Mass. Sorry, the other, maybe I should just use the same one of 349 Ashland Ave, Southbridge, Mass. 01550. Book 16302, 48510, page 30 and 294, tax plate 222, plot parcel number 23 and 24, and I so moved.
We have a motion. Do we have a second?
Second.
We have a motion and a second. All in favor?
Aye.
Unanimous? The little ones. Two big ones here. I don't think we need more than that. Usually we just sign two and that's it. Yeah.
Well, we're gonna sign those two, Guy. Do we need any to stay here?
He just takes that one.
Okay.
If you want to give them to us, we can put them in the file. It's up to you.
Oh, that Marshall.
There may be 5 here. I think so. See what we got. 3. There's 5 here. They haven't changed, right? I'll just keep these. We'll sign 2 copies of these. We'll give you this.
There are 5 then?
Yep.
I don't think you guys signed that. I'm gonna need that pen down there.
Just the one.
Sign these 2. Take that back.
These are the minutes that are signed.
Okay. Nope.
Is there one set of minutes still floating down there that I didn't sign?
There was one set missing without a signed signature page.
Oh, the 923?
Yeah.
Okay.
So we'll have to get those on the
Okay.
next meeting. They're already approved, so we can just,
Right.
if she puts in another signature page, we can just sign them.
You just signed them too, right? Thank you.
Okay, next item on our agenda for this evening, Ken Budkevich, CMRPC planner for rail trail mapping. Mr. Budkevich here?
No.
No. Okay, well, I think we'll skip that. And go on to our next item on the agenda, which would be a public hearing for the solar zoning bylaw change. I'll read the notice. Notice of public hearing. Please take notice that the Town of Dudley Planning Board will be holding an open meeting on October 28th, 2015, 7:15 at the Dudley Municipal Complex, 71 West Main Street, Dudley, Mass. The meeting is to discuss changes to the zoning bylaw, section 3.12.02, applicability of large-scale solar voltaic applicability of large-scale solar power generation or photovoltaic installations. The full text can be viewed at the Dudley Town Clerk's office. This was advertised on October 9th and October 16th in the Webster Times. Okay, so I have the public meeting open. Let me go ahead and read the article itself that's on the warrant. So this is going to be article number 23 at the town meeting on November 2nd? Is it November 2nd? November 2nd. Article 23 says, large-scale solar photovoltaic. To see if the town will vote to amend the zoning bylaw, section 3.12.02, applicability by inserting in place thereof the following. Large-scale solar power generation or photovoltaic installations are prohibited in residential districts 10, 15, 30, and 87, commercial district, business 15, light industrial district 43 and 87, conservation district and floodplain district. Large-scale solar power generation or photovoltaic installations are allowed as of right in the industrial districts of 43 and 130 and the town refuge disposal district. This bylaw is not intended to regulate systems of less than 250 kilowatts or rooftop-mounted systems. It is not intended to regulate systems that are consumptive power systems where all power that is generated is utilized to power on-site operations or take any action relative hereto. All right, so that's our article. And maybe, Marcia, you'd like to start. I know you had a lot of work on it.
Well, this room was filled with concerned citizens and abutters who were disappointed to hear this board's hands were tied in allowing the large-scale installation to be constructed as a business in residential neighborhoods. And they were bewildered when the board said it had no recourse but to allow the permit because of the way the bylaw was written. Among the different reasons, one was that it was permitted with, allowed with a special permit, and the special permit requires us to have an open hearing and alert the abutters. But when they were here expressing their concerns, they were told that there was nothing we could do. And one of the reasons was that the bylaw was written with no conditions to the special permit. And that's very unusual. Most towns' special permits have their own conditions separate from the site plan review conditions. So as a board of elected officials, it would be irresponsible to allow the situation to just continue without addressing voters' concerns. And at one of the subsequent meetings of that hearing, Mr. Mazziotti challenged me to take on that task. So the proposed changes to the bylaw were approved by Town Council and Green Community Committee. They address the town's residents' concerns, the town officials' need to generate revenue through business opportunity, and to meet the Attorney General's recommendations. The bylaw prohibits large-scale solar arrays to generate power for commercial enterprises in industrial zones, which protects neighborhoods and preserves the character of the town and protects property values. It also protects individual property rights, as it does not regulate solar to generate power for the property owner's private consumption. And it far exceeds the green community requirements of a town having to designate only one district of at least 1 acre. The designated industrial zones in town landfill include over 600 acres, giving the town space for that type of business growth. And it adheres more closely to the Attorney General's recommendations of siting and placement enumerated in model zoning of the Massachusetts Department of Energy Resources. And that, Dudley is a residential farm community. And the siting of the model zoning that the Attorney General's cites, I should read, where a solar facility is sited as well as placement on the site once selected is an important consideration, particularly in regard to large-scale ground-mounted facilities. The Department of Energy Resources strongly discourages locations that result in a significant loss of land and natural resources including farm and forest land, and encourages rooftop siting, as well as locations in industrial and commercial districts, which we've done, or on vacant, disturbed land. Significant tree cutting is problematic because of the important water management, cooling, and climate benefits trees provide. In regard to farm properties, rooftops are preferable. If roof space is inadequate, non-productive, non-arable agricultural land is a second choice. Should this also be proven feasible or inadequate, a dual use of land design concept could preserve productive farmland by continuing crop production underneath the high-mounted well space panels. Finally, if none of these are feasible and they are inadequate, the least productive land should be used first to minimize the loss of productive food and cropland. One would hope that the solar companies that come to Dudley are knowledgeable about the zoning model, since they're dealing in the trade of renewable energy to protect ecological alternatives. Let's see. So I think I've addressed everything. The townspeople's desires, the the officials hoping for or providing for business opportunities, and we complied with Green Communities and the Attorney General's recommendations.
Very good, and I think you did an excellent job on what you researched and put together for this article.
Any questions?
Yeah, so I have a couple comments. I agree and echo the chairman's comments about you did a lot of effort, put a lot of effort forth, and did a lot of research, and so I applaud you for that. And so I guess, you know, speaking to the town and the folks that are before us, you know, Marcia's right in that there were, you know, a lot of concerned citizens about a solar project that was before us, and, you know, as elected officials, we're responsible to do certain things and abide by Mass General Law, and we certainly did do that, and this obviously will, you know, give us, if it in fact is passed, will give us a new steering mechanism, if you will, as it relates to solar. But I think there were some, you know, some misunderstandings, as probably in most towns, about how this whole thing works. And I think it's, you know, great that we've been able to kind of see that we had a bylaw that was in place that planning board didn't forge, that the planning board didn't approve, that the planning board potentially supported, but ultimately the townspeople voted on. And what Marcia puts before us is no different than the other bylaw that was, I don't know if it's a unanimous or how that actually is voted.
Two-thirds majority.
Two-thirds majority at town meeting, but this obviously will, you know, will be subject to that as well. So, again, my point is it's incredibly important for everybody to understand that a bylaw can be written by any homeowner, any resident of the town, brought before the proper boards and officials to be fleshed out and supported, or opinion be made and brought before town meeting. And if the townspeople agree in a two-thirds majority, they have the ability to actually create laws for their own town, which I think is a fantastic thing. There's not a lot of countries that have that ability, but we do, and I think it's a great thing. Relative to my personal opinion on the bylaw as it is today, I think it's wide open, and certainly think that regulations are necessary to the current bylaw. I think that it afforded too much of an opportunity to create issues like we had created for the two large solar areas that were looking to be developed. But with respect to the position that I hold here, there's two things that I certainly have to keep in my mind, and that is the landowner's rights. The landowner buys a parcel of property based on a potential or a specific idea on what they want to use the land for, have certain rights and requirements for what they want to use it for, and also for the town. You know, what are the resource opportunities that the town has with particular land and developers. And so it's kind of a fine balance for me, is the way I treat the responsibility as a planning board member. So my feeling about what it was I indicated is wide open. My feeling about the new bylaw that is written, I feel, is very restrictive. I think that it limits the landowners and what they would like to use their land for. I'm not suggesting that the bylaw be written so that it can be so that large-scale solar farms can be put into residential areas like our current bylaw states, but certainly allows some opportunity in potentially a commercial district or a business 15, certainly a light industrial district 43 and 87. And those really are the only two that I guess I would question. So the current bylaw prohibits residential districts 10, 15, 30, and 87. I'm in total agreement of that. It restricts in commercial districts in business 15. I'm not in favor of that. Light industrial district 43 and 87 restricts that area. I'm not in favor of that. Conservation district and floodplain districts, absolutely in favor of that. Those are my comments relative to, you know, the specific areas that that these installations would be prohibited in. And I certainly think that if we limit those areas for developers to put a large-scale solar farm in, it limits town resources in that it's a very lucrative opportunity for the town and is able to pay a lot of things that need to be paid for in the town. But that's merely my opinion that I wanted to share with everybody. And Marcia, you know, in particular, as I encouraged her to put this together. Again, I'll finish by saying I think you did a great job. You did a lot of research, and I personally appreciate you taking on that task.
Thank you. Something that I forgot to address, the bylaw that we propose here is written according to Green Communities requirements that they're as of right, and so there's no public hearing or special permit with an as of right, so that there's not the same confusion. Why are we here? We're issuing our concerns and you can't do anything about it. So where it's allowed in those designated zones, it won't come to a public hearing.
Yep.
And I just want to eliminate.
It will for the site plan review.
Yes, for the site plan review, but not the permit.
Not for a permit, correct.
Yeah.
Yeah.
And as far as making money for the town with the pilot programs, there's a lot of discussion on that. I'm not so sure about the liquidity for the town. That's open for discussion, and that's why I limited it until we're really sure how those pilot programs work out with the different solar companies and LLCs and so forth. And until we know more about those specifics, I think it's better to leave it this way for now.
Okay. Anybody else?
Well, I just, I am in somewhat of agreement with what Mark said, but Marcia also has a good point as well. And, you know, we already have 2 of these installations slated to be installed, and I would like to see how, you know, the process, the pilot program works with these 2 installations. And in the future, although I do feel, you know, this is somewhat restrictive for, you know, future revenue for the town, I think it might be beneficial just to wait and see how these pilot programs move forward. And we can revisit this at a later date.
Well, yeah, this could always be modified or changed in the future, as previous ones were. We're on our second solar bylaw right now, so this would be the third. And you know, I think all bylaws from time to time need to be changed. The only comment I'm going to make when I looked into it was that you know, statistics are great. They can tell you a lot or they can tell you nothing. But and I don't know how far in depth the Attorney General's office will be when they go and look at this bylaw, but that's another thing to point out, that we could approve this bylaw, town meeting could approve this bylaw, and it could go before the Attorney General and it may get denied. Or it may have to be modified, and that could have to bring us back to the next town meeting. But what I did was I went and looked at basically the zones that are allowing the large-scale solar voltaic, the 3 zones that we're allowing, which are the 2 industrial zones and the town refuge zone, comes out to approximately 745 acres in the town of Dudley, which has a total acreage of just over 14,000 acres. So if you do it on a percentage basis, we're basically allowing large-scale solar voltaics in 1/2 of the town. So that means 99.5% of the land in Dudley is not allowed for large-scale solar voltaics. And the Attorney General may think that that's excessive. I don't know. The state law on solar installations does say that the towns have the right to reasonably regulate a solar installation. So if they think that this is reasonable, great. If they don't, then we'll have to come back and make some changes to it. But that's what I looked at when I first took a look at it, to see where we were going to allow it and what we were where we were not allowing it. The other thing I will say is that unfortunately a lot of that 745 acres is industrial land is already used. A large majority of that is owned by Webco Chemical Company, and they're right now in the process of expanding their site and their facility. So I don't think in any time soon that area would be used for solar generation. But that's just what I looked at. Again, I do think you did an awful lot of work, and I appreciate it for what you did for the town and for the board, Marcia.
Thank you.
Yeah, Mr. Chairman, the same can be said about the 14,000 acres that, you know, there are obviously residents and businesses and whatnot. So I think your percentage is fairly accurate, you know, kind of apples to apples. So, but not to further restrict that number.
Right. Okay, so what I would like to do now is open it up to anyone in the public who would like to make any comments. If you could come up and sit down at the table and sign in, and I'd like to hear the public's input.
Hi, Joe Bellavance, 28 Corbin Road in Dudley. And as an abutter neighbor of one of those solar farms, I have to applaud Marcia and thank her for all the work and looking at changing these bylaws, because as we all know, looking at each other, we've looked at each other a lot over the last number of months. So I thank the board, and Marcia in particular, for hearing what we all had to say and taking the initiative to look at changing these bylaws, because we did hear our hands are tied, there's nothing we can do. And I have to tell you that when I moved here 16 years ago, I didn't expect to see solar panels in my front yard. It was a residential area, and I think it should stay a residential area. So I hope that come town meeting, and I guess that's the next step, we're going to come to town meeting and we're going to bring this up, right? So we'll be there to talk about that. I do want to say, though, when you talk about percentages and the number of land and such, I got to say I'm disappointed to know that I'm going to have 1,700 panels in my front yard, and there's going to be a whole bunch of panels in front of the high school and the middle school entrance for $32,000 a year. When you talk about percentages, what's our total budget for the town? You know, $32,000 on millions of dollars. What is that really getting us? I don't know what's going to happen with Webco if they're expanding, what kind of money that's going to generate, but I'd hope it'd be a lot more than what these solar farms are generating for what some of us are going to end up having to deal with. So I think there might be better opportunities for development outside of that. I would like to, again, see this business restricted to certain areas. So, but again, Marcia, thank you, and we'll be at town meeting to have a discussion, I guess. So thanks.
Thanks, Joe.
Anyone else like to speak?
I just wondered if the board would care to talk a little bit more about the pilot program. I'd like to know how it originates, who negotiates for the town, and how those numbers are brought about.
It's, well, all negotiations for any type of payment to the town has to be done through the Board of Selectmen. They're the only board that's allowed to negotiate on behalf of the town. So basically what happens is the developer who's going to put in the solar panels, or it can be other, it doesn't have to just be solar panels. There's other things that are done in towns that pilot programs are used for. Wind turbines, some kind of landfills, if they're having private landfills, methane gas tapped off of existing landfills, they have pilot programs for all things like that. So the Board of Selectmen are the ones that do the negotiations. Usually they assign the town administrator to be their negotiator, and then the town administrator, along with the town council, will work to come up with a legal binding contract. And this pilot stands for basically payment in lieu of taxes.
Right.
So there's some things that can't be taxed, but there's some things that if the developer volunteers to pay taxes, you know, he's not really paying taxes, he's paying money in lieu of taxes. Some towns that have colleges, such Dudley has Nichols.
Some towns what?
Some towns have colleges. Colleges are not taxable.
Right.
Some colleges pay taxes to the towns that they're in the form of a pilot program. They pay the towns some amount of money instead of in lieu of taxes, because the towns wouldn't be able to survive with the, you know, or have the infrastructure they need for the colleges and the students if they didn't get anything from the colleges. So that's basically what it is. It's a payment plan. I don't have all the details for these two payment plans in front of me. What I do remember from the letter that the town administrator had written, the two solar facilities that were going in residential areas, the one that was in West Dudley and the one that was by the high school, over the course of 20 years was going to contribute to the town of Dudley approximately $2.3 million in lieu of taxes. The thing that I would also say is that the land that's by the high school, all that land, to my knowledge, is in what we call APR. It's agriculturally protected land.
It's agriculture preservation restriction.
So those people, those landowners on that land pay very, very little taxes. The town is collecting very little tax on that
So
land.
are you saying that the land where that Nexam facility is going to go across from Shepherd Hill,
Yeah.
that's an APR?
That's all that land's in APR, yeah, as far as I know. So that the landowners are paying very little tax. The town's collecting very little money. This, $32,000 versus nothing. I know it doesn't sound like a lot of money, but if you're getting nothing and now you're going to get $32,000 a year, it's a big difference for one plot of land.
So when this amount is determined by the town administrator, or the Board of Selectmen, however they come up with these numbers, is that number then go to the Financial Advisory Board?
No, it's whatever, it's basically, well, the first thing that has to happen before the town can even talk to the contractor or developer, there's usually an article in the town meeting warrant. There's one again on this town meeting warrant for the town to enter into pilot negotiations. So there's a third solar farm that's looking to be installed in Dudley. It's going to be off of Fabian Road, which is an industrial.
What road?
Fabian Road.
Fabian?
Yeah, it's an industrial zone, so it would fall right into this new bylaw that we're writing, that we have on the agenda, and that we have at the going to have at the town meeting. It would fall right into the right zone. So the Board of Selectmen is asking the townspeople at the next town's meeting to have permission to enter into a pilot agreement with this third solar installation that they want to put in off of Fabian Road. So once they get permission from the town, then they can go forward and negotiate the contract.
Are those meetings open to the public?
I don't think so,
Why not?
because this is money that they're volunteering to give. They don't necessarily have to give it. The developer's not under any, he's not under any legal obligation to give this money to the town. He's offering it to the town. And
In
basically
lieu
what
of
the-
taxes?
In lieu of taxes.
Right.
But like I said, this land is, in this one particular case, we're talking about APR land that's paying little to no taxes.
I'm very surprised that the powers that be in Boston would allow APR to have a solar installation on APR ground.
It's one of
Because
the,
they basically, it's in APR so it can continue to be farmed.
yeah, but that land right now is not being farmed.
Huh?
That land right now is not being farmed. It's
I
just sitting
understand.
vacant.
Well, there's a lot, Dudley has the second most APR
Yeah,
properties in the state behind Amherst.
right, which also means we have a lot of land that's not being taxed.
Right, right. So I'm not seeing the transparency. I guess that's my real,
Well, I believe most solar companies, when they set the amount that they're willing to donate to the town, this is what I've read about, they do it based on how much solar the farm is going to generate, how many megawatts the solar farm is going to generate. They make their money based on how much electricity they produce. So the more that they can produce, the bigger the solar farm, the more they're probably willing to pay for a pilot program. So I'm sure they all have, I'm sure the industry has a standard that's set at some number. You have 1.6 megawatts, and this is, X amount of dollars that you would volunteer to pay. I mean, I'm not an expert in it, but it's just what I've read and what I've heard from going to different meetings. But I mean, if you're interested in finding out more about it and how it's negotiated, I would just I would either go to a Board of Selectmen meeting and ask that question, or I would call the town administrator and ask him if he could give you an overview of how it's done.
I think I will.
Because we've done it, we have two, as far as I know right now, we have 2 pilot programs in place for 2 solar companies. There was a third company, the very first solar, large-scale solar field that was built in Dudley was mostly built it's off of Blackmere Road.
Right.
It was mostly built in Southbridge. They didn't even have to come to Dudley for any kind of permitting or approval. And as far as I know, we get nothing from that solar field. We get no pilot in lieu of taxes or payment in lieu of taxes. There's no pilot program with that solar field because only a portion of it is in Dudley, and because of a majority of it was in Southbridge, Southbridge got the payment in lieu of taxes.
So if all these solar companies are entering into a pilot program, what's to prevent other businesses in town from wanting the same treatment
What do you mean?
in terms of having a pilot program?
Well, other businesses are taxable in town. Like if you have an automotive shop here and you own a building, it's not on APR land. It's in a business zone. You're going to be taxed.
Right.
You don't have the choice. I mean, if you put a large scale solar voltaic system on the roof of your automotive building, then you might be able to enter into a pilot agreement with the town. But if you don't have something to offer the town other than your property.
So ultimately, do the townspeople have any recourse in terms of a pilot program? I mean, can't we approve it or disapprove it?
You approve it or disapprove it at town meeting when you allow them to enter into it.
Yeah,
If
but
you don't-
that's
if you don't-
only,
if-
that's only,
Initially,
yeah.
but ultimately, when you come up with when the powers that be come up with those numbers, then shouldn't the town be able to say yay or nay?
The way you got to look at this is kind of like all extra money for the town. This is not money that they would have gotten in any other way. This is like above and beyond what comes in from the taxes. So this is, I'm not going to say it's a gift, but it's an ability for the town to earn extra money. And once you give basically the Board of Selectmen the permission to go into negotiations, they're looking out for the best interests of the town, just like you would be. They're trying to get the most money they can from all these developers for these projects. The projects, they can only put so much on each project, and once the project is approved, the town administrator or the Board of Selectmen and the town council, they're all working for the best interests of the town. They want to try to get the most money they can from the developer, on a monthly basis, yearly basis. I'm not sure how it's paid, but they want to get the most they can, and that's what they go in and negotiate at.
Okay.
But you're negotiating with someone who does not have a legal obligation to enter into that agreement. That's the difficult part of it. That's the difficult part of the negotiation. You don't have to pay tax. You're putting in a solar array. You're going to do the right thing because you want to do the right thing for the town. So we're having a negotiation and you want to pay X per kilowatt that's generated, and we'll say, well, we really think you should pay Y. I want to pay X.
Yeah, I mean, you got to remember.
Can't make you pay Y.
Mm-hmm.
You got to remember that these solar companies are in business to make money too.
Mm-hmm.
So I mean, they're basically they're willing to cut their profits to put these installations in different towns.
Mm-hmm.
So
one more question. What is exactly the status of the Easterbrook solar array installation? Is that a done deal? Is it going to go through?
as far as I know, the one near the high school and the one in West Dudley off of Fish Road are both approved, and at some point in time they will be built, unless the developer decides not to build them. I mean, they're approved as far as the town goes. There's a pilot agreement signed in the office, but whether something from an economical standpoint comes up, or they get a better deal in another town, I don't know. I mean, they obviously both have money invested in these plans. They both planned them out. They both came to town meetings and had public hearings.
Mm-hmm.
They've had engineers design them, and they've had lawyers represent them, so they both have a fairly substantial investment in these projects. But projects die every day. I mean, as far as it goes from the town standpoint, they're approved. Whether they get built is up to the...
But they have not pulled a permit yet?
Not that we're aware of, yeah.
Okay.
Yeah.
All right. Thank you.
Okay. Is there anybody else that would like to talk?
Hi, my name's Michael Mayotte. I'm on the Dudley FAA, and we're also struggling with trying to understand what's going on with the solar agreements. We've had 3 now been put on warrant article that in less than a year and a half. So we're really trying to understand what's going on. And so these are very difficult things to understand.
Oh, yeah.
And I want to commend Marcia for actually really looking into this and looking at this bylaw, because just throwing this stuff out, it can open the town up to lawsuits, basically, if you don't know what you're doing. And we looked into the bylaws of other towns, what they've established, and I think that bylaw that's going to be voted on is pretty consistent with that. The pilot agreements, to answer the previous, some of the questions that the previous person was here asking, I think there's a little misunderstanding on what the pilot agreement is. Basically, it's a business. Business comes in, it's going to build a facility on a piece of raw land. They're going to lease the land, or they're going to buy it. They put a facility up. Unfortunately, their business model doesn't allow them to make. They don't make enough money to pay what the taxes would be on that. So if you put up a $10 million facility, even in a tax rate town like Dudley, as low as Dudley is, they still can't make enough money. So they have a bad business model from the get-go. That's why they apply for pilot agreements. And I understand how the town wants to have that, because it's getting more money than it would otherwise. So I guess that's a good thing. But there's a lot involved in these things. There's a lot of legal stuff. So we're all new at this, trying to figure out what it is. As far as the pilot agreement, if you guys read the Warren article, there's no enter to negotiate. It's enter. And that's how it reads.
Okay.
We don't have a negotiated pilot agreement. The Board of Selectmen haven't negotiated numbers. They haven't come in front of you and done a site plan. They haven't gone in front of the zoning board. They haven't done anything. We don't have anything, yet we're being asked with this warrant article to enter into the agreement. I don't understand how do you enter into an agreement if you don't have one. So these are the questions we're starting to bring about on the FAA. Is we don't have any information to enter into an agreement. How do we do it? So, you know, any information we can get from you guys would be appreciated on that.
Okay.
So, and the other question she had about the amount of money on the pilot agreements. You mentioned something about $2 million.
2.3 was what the
Do you
letter.
know where you got those numbers from?
Town administrator.
Okay.
He wrote a letter.
The last pilot agreement that we had approved started at 12.5, went up a little bit for 20 years. If you do the math on that one and the math on the first one, you're getting anywhere close to $2 million. So I don't know. There's some numbers that have been sent out that say we got all this money coming in. It's not as much as we think it is. So, and the only other thing I can add to that is when we started looking into this on the FAA, started looking at all these other agreements in all these other towns, one of the things that came out was a special permitting fee that most towns had incorporated. And I want to thank Greg Baculanis for actually bringing that up to the selectmen. And now going forward, we have an actual upfront special permit fee now that we didn't get on the first two. So this is why we're on the FAA. We're really starting to look into this stuff, because they are very complex, and we don't want to give these things away. So.
Well, I know that there's the same company that proposed the one by the high school, Nextamp. They did a solar farm in Rutland, right abutting the Treasure Valley Boy Scout camp. And I was told that basically it's on the Treasure Valley Boy Scout land that was, that land wasn't being taxed. It was being, it was like in a conservation district or something like that. But they put that solar farm in, and I believe that one nets about $165,000 a year.
How much a year?
$165,000.
Do you know how much megawatts it was?
You know.
Well, at one of our FAA meetings, we brought this up. We were looking at the Uxbridge one. Uxbridge had about the same size plant as the recent one we just passed. It was a 4.4 megawatt, and they were up over $60,000 a year on that annual pilot agreement. On the one we did, we were at $12,500. So you know, these solar panel companies that come in, you know, it's great that they're gonna bring revenue in, but we've gotta be a little bit more shrewder on how we negotiate with these guys. They're coming in to get the best possible deal they can possibly get. We need to get the best deal we possibly get, and it's gonna take all the boards together to kind of, people on all the boards, to put our heads together, make sure we're getting the best deal, that we're not gonna get sued, that everything, all the I's and T's are crossed. So any input from you guys would be appreciated on this, as far as members of the FAA are concerned, so.
Okay, thanks, Mike.
Thank you.
Anyone else like to speak?
Hi.
Hi.
I too would also like to thank you for all your effort. I was at the meeting last spring, so it was kind of confusing then, and it's nice to see that maybe we are heading in a way that will clarify things and help everybody in the long run. One concern that I have, and I don't know if it can be answered here, but I do remember from that last meeting when that large-scale company was here presenting their plans, that it was discussed that they had considered commercial areas in the town, and I believe that they stated that those areas were not feasible for their large solar farms. So my concern is that if those are the only areas that we're giving them, so to speak, in this amendment to the bylaw, would the Attorney General be able to determine that this area may not be feasible, and then therefore this amendment would be denied, I guess?
I mean, we can't, nobody's going to know what the Attorney General is going to rule on until we put it before them. I mean, if we take this to town meeting and everybody votes on it, it gets passed at town meeting, then it gets automatically sent to Attorney Generals. The bylaws don't take effect until the Attorney General approves them. So we can approve them at town meeting in November, on November 2nd, and usually within 2 to 4 weeks, we hear back from the Attorney General's office after they review them. Like I said, I don't know how deep they dive in when they take a look at these bylaws. Do they do a percentage base like I did on land? Do they look at the land that we're offering, if it's all developed, if it's not developed? You know, I don't know how they look at these things, or if they have somebody that actually looks at them that deep. What I do know is that our original bylaw that we adopted the town of Sutton's bylaw, which basically denied large-scale solar voltaic systems within the town of Dudley or the town of Sutton. We adopted their bylaw letter for letter. We went to town meeting, we had it approved, we sent it to the Attorney General's office. They didn't deny it, but what they said to us in the letter back was, your bylaw is not defendable in court. So what that meant was if some large-scale solar company came to Dudley and said, we want to put one in, and we said, no, you can't, our bylaw says you can't. If they took us to court, they would win, because the state law says you can reasonably regulate it. It doesn't say you can prohibit it. You can reasonably regulate it. So that's going to be their interpretation of this bylaw that we're submitting to them. Is 1/2% of the town of Dudley reasonably regulating, or is it over-regulation?
Right, and I guess the only thing that I questioned was when this solar company did assess the town for areas that would be feasible, what was their reason for not choosing some of our commercial? Because they didn't really get into any detail. If I remember correctly, they just said these were not feasible areas.
It could be, it could be.
And I just wasn't sure if the town knew.
No. I mean,
how the solar company assesses
Right.
these areas.
Obviously, if you're putting a solar field in, you want to make it as easy as possible. So if you can find a large open field with a southern exposure and nothing impeding its sunlight, that's the greatest thing you can find if you're a solar company. So that's what they're looking for, you know?
And I think they also may look at avenues to convey the power that they're generating to the grid.
Okay.
Yeah, that's a
Well.
good point. Yeah, I mean, if you happen to have high-tension power lines running right next to a large open field, and they can just, hook the power right in and put it to the grid, that's a win-win for them, because they don't have to build any infrastructure to carry it away.
Okay.
The one that you just mentioned is not Fabian Road, I believe it's Farley Road? Is that what you're, on Center, it borders Center Road and Route 31 on
Oh, okay,
Farley
yeah,
Road?
you're right, I think
That's industrial, and it's really kind of a catch-22 because it's industrial, it's open fields, it's a farm. So, and that's the next proposal. So we do have that available in Dudley, and but by the same token, the Attorney General's office refers us to the Department of Energy Resources, and they say not to put it on fields and farmland where you can grow crops, hay or corn for the cow, our one dairy farm. So we're making that available. Is that going to be a catch-22 because it's farmland? I don't know.
And then the only other comment I had, because it's one of the things that has bothered me since attending that last meeting, hearing the discussion with the abutters and other concerned citizens, and that is I do see it fairly objectively with what the town is trying to accomplish, but at the same time trying to make the community happy for the most part. My concern is that when these sorts of things do impact a residential area, I know one of the main concerns for some of the abutters and people in the general vicinity of these huge solar farms is the value of their property. And that has always concerned me, since kind of reading about this and looking into it a little bit more. I don't know if they've done studies where they actually have statistics on, what does happen to the property value of homes in the surrounding areas when these huge solar farms come in. But I just find it interesting that, or I think the town takes a risk at making $32,000 a year at the cost of possibly watching some of their residents lose value in the only asset a lot of people in this town may have.
I agree, and that's another piece of the pie that we have to consider.
I would hope that we would look into that more now that we do have surrounding towns that have gone into these programs, pilot programs, if that's the right term, to look into that a little bit more, because I know, that is a big concern to me. I don't have farmland next to my house or across the street or behind me, but as a person of Dudley, it still concerns me.
It's a legitimate concern, absolutely.
I know that the two houses that are going to face the solar field by the town hall have gone up for sale since this solar proposal. There's a for sale sign on one of them now, and there was one previously. I don't know if it's sold or not. And I know someone who owns acreage, substantial acreage, looking at the solar farm in Rutland. The property was valued, the land was valued at $150,000 because of the scenic view. Now it is worth $85,000. So the town is getting less revenue for that piece of property. So there's a lot of pieces to this pie that have to come into consideration. I haven't seen studies, but I know that specific incident, and I know the two houses that are up for sale across the street from the high school now.
Thank you.
Thank you. Anyone else?
I just have one quick question. My name is Don Wilson. When Mark was talking about putting things in Business 15, is there a particular size of a lot that's required to put these large solar scale?
Yeah, there has to be a minimum of an acre.
Okay, and would that be included in Business 15?
Yeah, there's you can have any size parcel you want in Business 15. It has to be a minimum of 15,000 square feet to be a legal lot, but to put a solar array on it, you need a minimum of an acre, so you'd have to have a lot that's an acre or larger.
Well, I just wanted to make sure that we did have some type of, checks and balances to make sure you just couldn't put one of these things, in taking up a whole small lot. And if you bought a whole bunch of these lots, you could just keep on putting these small amounts in to add up to your large one.
You have to have a minimum of an acre to start off with. It's not really feasible. It's not financially feasible for a large-scale solar voltaic to be in. I don't even think it would be feasible to do it on 10 acres. I think you need like 40 or 50 acres to do it and make money with it.
Right, but do we have anything that states that?
Well, that's the economics of the system.
I understand, but as a town,
No.
if we wanted to try to preserve some of our land so that it's not being used for this particular purpose, wouldn't it be nice to have something that you could say, we require you to have this as a minimum size parcel before you begin?
We do. We have the minimum of 1 acre. That's what was in the original bylaw, and that's what's still in there today.
Okay, and that's not going to change?
It could if we wanted to, but right
But it
now
won't change with this new one?
it won't change with this new one. No.
Okay, well, that's just my thought.
I don't think we have a problem with people trying to put a large-scale solar voltaic on a 2-acre lot because it's not going to make them any money. So I think that's, I don't know what the threshold is for where it becomes profitable, but my guess is it's a lot more than 1 acre from what I've seen.
Okay, because I'm just noticing that, the ones that's on Estabrook, those are not very large lots.
Those 4 solar arrays were like 80 acres worth of land.
Are they going to be using the entire 80 acres for
No,
No, just, I think 12.
10 or 12.
Yeah.
See, that's, just wanted to make sure that it's not going to be something that's going to be available for every neighborhood.
Right. The other thing you have to consider, though, is if you're putting one of these up, and let's say you had a 2-acre lot, and you were putting one up on a 2-acre lot, if your next-door neighbor built a house or a building next to you and cut your sunlight off, you're out of business. So you want to have some acreage around your panels so that things don't start impeding it.
I just wanted to make sure that this board has, some options.
Yep.
Because it just seems like they can put these things anywhere based on what we have now. And now, even though we're restricting it, he had mentioned that, Business 15, some people have rather small lots for Business 15.
Oh, yeah. Well, yeah.
Yeah, the bylaw is written that it would not be allowed in Business 15.
Right, but that was one of your questions, that you'd
Right.
like to see it expanded to
Right.
that. I just wanted to make sure that there were other controls, just to make sure that, you just couldn't
Sure.
put one anywhere.
Right.
That's all.
I have a question. Are most of our Business 15s in our town both residential and business?
Yes.
So, again, if we're thinking about solar in Business 15, it's going to encroach on residential dwellings, and most people I talk to don't want to see that in this town. And I represent the town in that, and so I'm trying to represent the townspeople's desires to keep the town looking the way they moved here to live, in a residential, rural nature character of their town.
So Business 15, Marcia, someone could put an asphalt plant next to your house.
Possibly.
I would rather a solar farm. But I'm
You laugh, but I just heard that kind of a problem going on in Colorado. A friend in Colorado is opposing that in her residential area, an asphalt plant right next door to her.
No, I'm not trying to be funny. It's just, that's
you
the,
just-
yeah.
Yeah.
If you're in a Business 15 and you have a residential home, that's, unfortunately,
it's 2 allowable uses. So, yeah, I mean, the other thing you have to remember, too, is that it's impossible to write a perfect bylaw that's going to work in any town for any and all situations, because no matter where you are or what's happening, somebody will always come up with a situation that nobody ever took into consideration when they were writing the bylaw. So I've tried to write numerous bylaws myself, and you can't sit down and think about it all, because you'll never finish the bylaw. At some point in time, you have to say, okay, this is what we're going to put forward. It may not be the best, but it's something to start with. And then, like I said, these things continuously work themselves out as more and more solar installations go in, and people see, oh, I don't like this, or this is definitely a negative, or they'll see the negatives right away. Again, they may see some positives, and they'll say, okay, this is good, we're not changing this, but for the next bylaw go around, let's put X, Y, and Z in, and let's put more of A, B, and C in, because we like that. It's continuously changing, and I don't see in the future that it's going to go away. It may, but at some point in time, it may not be. We may not have to worry about solar panels, because it may be something different than what we're used to seeing now. It may be everybody's got shingles on their roof that generate electricity, and you don't even have to worry about it. It's all there, or they pave the roads with panels that create electricity and heat up in the wintertime, and you don't have to plow them or sand them. There's all different things that technology can bring forward that in 20 years from now we may not even have to worry about this. But for right now, we are where we are, and we're trying to do the best based on what we heard at the last meeting. And again, I got to say, Marcia took it upon herself to do this, and I think she did a good job. Is there anybody else that would like to talk? Okay. Well, hearing nobody else to speak, I'm going to close the public hearing at 8:12. Okay, so now we have to decide. I don't know how many of you were planning on going to the town meeting on, was it Monday, November 2nd? I believe we do have a meeting scheduled at 6:30 in the cafeteria. We can discuss this again there and vote on it there, or we could take a vote on it tonight, and then not everybody has to show up at the town meeting. It's up to the board. I'll leave it up to your pleasure, what you'd like to do. We can either vote on it now, or we can wait until the next planning board meeting.
Do you all feel you could make a sound judgment right now? Okay, why don't we do it?
All right.
I would like to share with the board that, and I don't know if this is the right time to say it or not, but my vote is not going to be in the affirmative, and my concern is, and if you want to wait as a result of this information, we can do that. And the reason that it's going to be not in the affirmative is because my concern is that it's too strict. And if it's too strict and the Attorney General does not approve it, we go back to what it is today until May. And the number of solar farms or solar applications that could come in my opinion, a bylaw that is wide open is a very risky position. So I just wanted to put it out there for that reason.
I hear what you're saying, Mr. Mazziotti, but I mean, my opinion of it is it is what it is. I think we have to wait till the Attorney General has her chance to review it and give us her feedback. I mean, I think, worst case scenario, she denies it. Best case, she approves it, or it may be something in the middle where she comes back and says, like the first one, we'll approve it, but if you go to court, you're probably going to lose. If they allow it to stand for 6 months until we can do something different.
So let me ask this. So if it does go there and it's either an approval or a denial from the Attorney General, or do they say, if you made we suggest that you change the wording to this or this, and we'll approve it if that's the case, but if that were the recommendation, it would still have to go back to...
Yeah, on our first go-around, she said it was too strict, it was too restrictive, and they felt that if they approved it and let us go forward with it, but they said based on the lack of legal There wasn't that many solar lawsuits at the time, so they didn't know how they would play out. But her recommendation was that we make it less strict than what we had. Otherwise, if we were to be sued, her legal opinion was that we would lose the case. But they did allow that first one to go through because it was in place for a few months until the first applicant for a solar farm came to the town of Dudley and asked for an application and was told it was denied. So then, that's when everybody started taking a hard look at it. And just by the way, so everybody knows, the current solar bylaw that we do have that is, I agree with you, wide open, was written by our town council. So we didn't know how to write a solar bylaw, so we asked him for his help, and we paid him to do it, and this is what we got. So we went from one extreme to the other, and now we're trying to go back. So we have to, at some point in time, we're going to find a happy medium. I mean, and the other thing is whether the planning board, us as a board, endorses this or not endorses this. It's up to the 2/3 majority vote at the town meeting. We can get up and say we don't endorse this, but if two-thirds of the townspeople endorse it, it goes forward to the Attorney General. So after that, the only person who can stop it from being a bylaw is the Attorney General's office. So if the townspeople say yes, we want this specificity of restriction on a bylaw, and they vote for it, and it goes through, and the Attorney General says yes or no. If they say yes, it goes forward. It's bylaw. If they say no, then we're back to square one.
Right.
So.
And that, of course, is my concern. Based on the audience that we typically attract at the last 10 town meetings that I've been to, I don't see any reason why this won't pass. Personally, I don't have any concern that this will pass at all. My concern is what happens after that.
Yeah. I mean, to try
and having to live for another, 6 or 8 months with.
Well, we're kind of stuck with that because the problem is to change this to make it less restrictive.
Right.
I think. I mean, I'm not an attorney. You'd have to talk to the town moderator and town council if it's even possible to make changes to this, because we've already advertised it as this. We've already had a public hearing on it.
Okay.
So I think right now we're kind of stuck in the middle. So, all right. So is everybody still in agreement to vote tonight? And that way, if we don't have a quorum for the town meeting, we can still go forward. Okay. All right.
I just think if we don't vote in the affirmative, we're still stuck with the same bylaw until May, regardless.
Which still gives us the ability to regulate.
Mm-hmm.
Yeah. I mean, my opinion is we put this one forward, and if the Attorney General shoots us down, we're back to where we were, and then we come up with one that's a little bit less restrictive and send it back to her and see what she thinks.
Okay. That's a very good point, Mr. Holt, and I certainly don't want to, I can't alone be a barrier to this warrant, but I don't know and don't want to know what anyone else is thinking. So based on your comment and the discussion that we had, I think I've changed my idea of, because ultimately, at the end, I want it to go through to the attorney, the Attorney General. I want them to approve it, but I have no control over that.
Right.
But obviously, if it fails tonight, then we're in the same place.
Yep. Okay, so we're looking for a motion to approve Article 23, large-scale solar voltaics for the Town of Dudley zoning bylaw, section 3.12.02. We have a motion?
I'll make the motion.
Okay, we have a motion.
To approve.
Motion to approve. Do we have a second?
Second?
We have a second. All in favor?
Aye.
Aye.
Okay, unanimous. So the planning board will endorse this article. Thank you. Okay, next item on our agenda. Item D, open meeting law violation. So I don't know if everybody had a chance to, I know not everybody was here at the last meeting, but Marcia was good enough to make copies of the 4-page letter from the Attorney General's office and put it in everybody's packet. So if you didn't get it last meeting, you should have it this meeting. I had a meeting with town administrator last week, and he had informed me that the town council's recommendation for us was to appeal the Attorney General's decision. So the Attorney General, the lady from the Attorney General's office did contact me and asked me what our decision was, or what we were doing, and I had notified her that we had deferred to town council, and he was going to represent us in the matter. So she asked that I forward her information to town council, and I gave that off to town administrator last week when we met, for him to forward to the town council, so the town council could get directly in contact with the Attorney General office and see how this works out. I don't know if it's going to require a hearing where we'll have to go individually to a hearing, or how it works. But that's where we are right now. Town planner replacement is the next item. Again, last week when I met with the town administrator, we reviewed our options for an interim town planner, and basically there's not a lot to pick from. So basically what we're trying to do right now is we've asked Central Mass Regional Planning, they're coming tomorrow, so if anybody's interested in meeting with them, they're going to be here tomorrow morning at 8:30 in the planning board office. They're coming to do basically an assessment of what we need and the current situation that we're in. I informed them on our phone conversation that we have right now literally hundreds, if not thousands, of pages of paper out of files, and they're out of place, and they need to be reorganized and arranged and put away in proper locations. Obviously, it may not take a planner to do that, and they do have clerks and office help that we can also attain from them. But they wanted to come out and assess the situation and see what it is. I mean, I think we need somebody that has some planning background to go in there and pick up the piece of paper and say, okay, this is an A&R plan, it's going to go in the A&R folder. Okay, this is a subdivision plan, it goes in the subdivision folder. Because, I mean, if you just bring a clerk in, they're going to just file stuff and we're not going to know where it is. So we need to get that office straightened out. And we're looking at this basically to finish out the year. And, I think the best thing for us to do after that is, hire this as an interim for the next 2 months, November, December. And then we're going to need to have a meeting with, I believe, the town, the Board of Selectmen and the Personnel Board to go over what our requirements are going to be for the future. Do we need a town planner? I mean, it's been almost a month since Nancy left, and, the wheels haven't fallen off the bus. So right now we have Joan Gardecki, who's kind of the town floater, working in the office, 4 hours a week, or
She's doing a great job.
8 hours a week. I mean, we're getting our minutes done, we're getting the agendas published, she's taking all the phone calls and getting things arranged. I was talking with Central Mass Regional Planning and telling them that we were looking probably for somebody like 45 to 50 hours a month is what we need, in my opinion. And I would like to see the office open Monday and Tuesday, Thursday and Friday for like 3 hours a day, and then have somebody that could come to the planning board meetings. I mean, obviously, if we had a planner from Central Mass Regional Planning here tonight and we wanted to know in-depth discussion of pilot programs, that person probably could have gave us all the perspectives and all the details, because they know it, they've seen it, they've done it. As it's new to Dudley, it's not new to the rest of Worcester County. So, I mean, I do think there's some value in having somebody here for a planning board meeting, and then have somebody that could help us out when, the next site plan review comes in for a solar farm, or for a new restaurant, or for whatever else pops up. But, long term, we have to sit down with the Board of Selectmen and the Personnel Board and see what we can do. And then we also have to look at, maybe take into consideration our friends in the FAA. Is this the possibility to save the town some money?
So how would that assessment be funded for CMRPC to come in and,
For the next 2 months, it would be, the money would be the leftover remaining,
Credits.
no, it's salary from the former town planner's salary line item. So we have, I believe, almost $28,000 left in that account.
But don't we have hours banked with CMRPC also?
We do, but they would probably use that up in less than a month.
Okay.
So, yeah, we can use some of the hours with CMRPC, but that was what Mr. Bukevich was here tonight for. If he was attending this meeting, he was asking to have 6 hours from that credit to have a new map done for his rail trails. So, yeah, I mean, I think we have plenty of money to do what we need to do. And ultimately, once we get things straightened out in there, I mean, maybe a clerk is fine, I don't know. Or maybe we talk about some other things. I mean, one of the things I've thought about for a long time and mentioned in the past was maybe we look at getting a engineer for the town of Dudley that could also act as a town planner, and that all that money that we collect from various developers that come to town and then we give out to our consultant town engineer, we could keep that in-house. I mean, I just had the numbers pulled on that, and for the last 9 years, we've gave Graves Engineering approximately $140,000 in the last 9 years. And, you know, we haven't had a lot of development in Dudley in the last 9 years. It's been relatively low.
That's not our expense, that's developer's expense, right?
That's developers'
But it would be
expense.
our revenue.
Yes, so that's money that basically comes into the town and goes right back out.
Right.
If we employed an engineer that could do those reviews for us here in town, we could keep that money. And the other thing that I looked into was the hourly rate that's charged by Graves is still at $150 per hour. And the average rate for civil engineering in this area is anywhere between $200 and $300 an hour. So if we had an engineer in our employment, we could easily charge more money than we're currently charging for reviews. You know, obviously we wouldn't want to be the highest place in the Commonwealth, but we don't have to be the lowest either. So I mean, if we ended up coming up with a $250 an hour charge for the town engineer, and you know, added on top of what we already know what we spent in the last 9 years, that basically would come out to about $25,000 a year in revenue for the town.
so if during that assessment, it was found that there was a lot of documents that were due to be archived, who would handle that?
The gentleman that's coming is a planner for Central Mass Regional Planning, and once he makes his assessment, he's going to let us know who he thinks would best fit for our town and what type of help we need. Like you were saying, if we need somebody to answer telephones and just sit in the office, you don't necessarily need to be paying a planner, which I'm sure is a higher hourly rate than you know, someone that works out as a clerk. But you know, you may need somebody for a day or two to go through all the piles of paper and figure out what they are and put them in consistent piles, all the A&R plans in one pile, all the subdivision plans in one pile, and just organize it, you know, that way by piles, and then have some clerks come in and file everything away. You know, I don't know what his. I'm waiting to get his take on it when he sees the situation we're in, and you know, I don't know if he's going to walk back out the door or if he's going to have a game plan for us, but I'm hoping he can help us.
Come on, guy, it's not that bad.
Okay. So,
Shower curtain off and go.
yeah.
Yeah.
So that's where we are on the planner's replacement. So I think definitely by next week we will have somebody working in that office other than Joan, and able to do some of the more technical things for us and help us out. And then the only other thing we have on the agenda is planner's plate. Apparently there's an application available for battlefield preservation grants. I'm assuming it's in the planning board office someplace. And then our item G, comments from the planning board. Do we have any more comments? And item H, comments from our audience. Is there any more comments?
Good job.
Thanks. Okay, so motion to adjourn, I guess.
I'll make that motion. Second.
Motion to adjourn in second. All in favor?
Aye.
Aye. Thank you.